All rise. Within a district court is now back in session. The Honorable J. Cedric Simpson, President.
Maybe see. Court does call the case of the People versus Jules Calphone.
Good evening, Your Honor. Elvis for the people.
Your Honor, Sunita Dadamani on behalf of Mr. Calhoun.
Was there anything from either side, or did they? Well, before you begin, let me just say a couple of things. I'm not sure that people sometimes understand how courts work. I'll speak certainly for this court and this judge. The decisions that the court has to make are certainly balanced upon certain things. I've received a number of communications not coming through the parties. I've shared those with the parties. But people should understand that those don't sway me one way or another. The court's decision, while we live in a country that's democracy, so it says, my decision is not a democratic thing. I don't go on votes. While I appreciate people's opinions about things, some of which I may vehemently disagree with, the way to get that is those that may want to get things through the prosecutor's office, who feels that they're on that side of the issue. There are victims advocates and others that can get that communication to the court, and in a manner in which counsel can look at it and determine whether or not that's something that should properly come before the court, because they know. And from the defense side, same thing. While I appreciate you guys wasting the paper and the ink, those have no bearing on me. I'm going to make my call based upon what I see, what are the facts of the case. It also, I will just say, I read every one of them. And with all due respect, some of the comments, and I say this and with all the respect that I can possibly muster, things aren't factually based. The facts that some of these things are predicated on don't exist in this case, which is sort of makes a lot of it, in my mind, sort of statements of ignorance as to where they're coming from and conclusions that then come through that. So I would suggest to those that may want to write to the court or information that they work through the appropriate ways of doing that. Send it to counsel. Let counsel decide if it should come before the court, because otherwise, again, it's not going to have any bearing on me. Certainly not at this stage. I also am troubled because we are at a stage where the court is just dealing with bond consideration. And there are statements that are made have flipped everything about American jurisprudence on its head, because there's this presumption that Jules is guilty. Folks, understand something. He has not been convicted of anything. Nothing has come before the court that has rendered any decision about any bit of his conduct. And I don't know myself, in terms of the evidence that's there, whether or not that evidence is going to be sufficient that a conviction would even occur. But everybody is quick to just presume he's guilty. And maybe people should take a moment, based upon what I see in these letters, and reflect upon that. Because some of this, while they try to couch it in other terms, and I say this in a respectful way to Jules and others like him, some of the presumptions are being made that he is something because he's different. It's not how we work. That's not how this court works. That's not what we don't do things to people because they may be different, because they may conduct themselves in different ways. I am looking solely at the allegations that are in the case, the facts, and the facts of the case. I'll emphasize that word, the facts of the case as they relate to these particular charges. So I would ask that you just refrain from doing that. If you want to send it, you send it. They're going to end up the same place that everything else is and going to have the same impact on this judge. I've been doing this a while. I know what I'm doing. I get it. And I will just say as a personal note, I'm dismayed as a family of educators and being an educator and professor myself with some of the presumptions of people who presume to be or say they are educators. Because sometimes the primary job of an educator is in a room full of kids or a room full of students. You have to deal with those that are of the least and those that are of the highest. And you have to do for both of them. And some of the statements that I see from some of the teachers, it distresses me, being a product of the Ann Arbor public school system myself, that there are teachers that believe that because Jules is who Jules is, it seems they don't want to deal with children that may be like him. That is what I see. Ma'am, you can shake your head all you want. If you want to talk in my courtroom, you don't get to talk here. And you can take yourself out into the hallway. You hear me? Am I understood? So what I am going to do and what I've elected to do is to adjourn this hearing. There may be things that I may request of counsel, such as a full threat assessment. So I may be requesting that. I haven't made that final decision and determination on the bond and its conditions. I'm going to adjourn that to September. I was going to do the 3rd, but 10th. The 3rd doesn't work for council, so I'm going to adjourn this to September 10th, 2026.
Thank you, Judge. May I request that it be in the morning section of the
I
document?
want it morning.
If it's possible, I have to be back in Detroit at 5, and I'm not sure I could make it if we set it for the
If
afternoon.
it's like today, yes.
Thank you, Judge.
Ms. Valtez, you have any?
Not at all, Your Honor. That's
I'll set it at 9. Is there anything else?
No, Your Honor.
no, Your Honor.
All right, bond will continue. Thank you. Thank you, Jules.
Thanks. Bye.
Bye-bye. 14A. 14A stands adjourned.
The district court session begins with the court calling the matter involving the people and Jules Cohen. After the case is called, counsel acknowledges the court and appears on behalf of Mr. Cohen. Before proceeding, the judge pauses to explain how he approaches decisions in this courtroom. He says that people do not always understand how courts work and makes clear that judicial decisions are not based on popularity, public pressure, or the number of people who support one position. He has received a number of communications from people who are not parties to the case, and he has shared those communications with the parties. Nevertheless, he states that the communications do not sway him in either direction. The judge explains that although the United States is a democracy, a judge does not decide a case by taking a vote. He may appreciate that people have opinions about the matter, including opinions with which he may strongly disagree. But those opinions are not the standard by which he decides the case. If people want information or concerns brought before the court, they should use the proper legal channels. Those on one side of an issue can communicate through prosecutor's office and through appropriate counsel. Victims, victim advocates, and others may also provide information through the established process so that counsel can review it and determine whether it should properly come before the court. The same principle applies to the defense side. The judge then discusses the letters and other communications more directly. He says that although people may have spent paper, ink, and effort sending them, those materials do not determine his decision. He says he will make his call from what he sees in the case and from the facts. He has read the communications, but he says some of the comments are not factually based. In his view, some statements rely on facts that do not exist in this case, because conclusions have been built on non-existent or inaccurate premises. He describes many of those conclusions as statements, showing a lack of understanding about the actual circumstances. He therefore advises anyone who wants to provide information to send it through counsel and let counsel decide whether it should be presented to the court. The judge stresses that communications submitted outside the appropriate process will not have a different effect on him. They will end up in the same place as the other outside material and will not change his decision-making. He says this especially matters because the court is currently dealing only with bond consideration. Despite that limited stage, he has seen statements that appear to assume Jules is already guilty. The judge says that such assumptions turn the basic principles of American jurisprudence upside down because Jules has not been convicted of anything. He makes the point repeatedly that the court has not rendered a decision concerning Jules's alleged conduct. Nothing before the court at this stage has resulted in a finding that Jules committed the alleged conduct, and the judge does not even know whether the evidence will ultimately be sufficient for conviction. He says that he cannot determine from the current stage whether the evidence will be enough to produce a guilty verdict. Nevertheless, he observes that many people are quick to presume guilt. He asks those people to pause and reflect on what they are saying, particularly when their conclusions are based on the communications he has received. The judge then addresses another concern. He says that some of the assumptions about Jules appear to arise because he is different or because he conducts himself in ways that others may consider unusual. The judge says that this is not how the court works. The court does not do things to people simply because they are different or because they conduct themselves differently. His focus is supposed to remain on the allegations contained in the case and on the facts relevant to those allegations. He emphasizes the facts again and says that he is looking at the facts of the case as they relate to the particular charges before him. The judge asks people to refrain from making assumptions based on difference. If they still want to send communications, they may do so, but he warns that such communications will have the same effect as everything else that is not properly before him. He says he has been doing this work for a long time and knows what he is doing. His position is that the case must be handled according to the facts and legal process rather than public impressions. The judge then makes a personal observation about education. He says he is dismayed by some of the assumptions being made by people who describe themselves as educators. He explains that he comes from a family of educators and is himself an educator and professor. Because of that background, he finds some of the comments especially troubling. He describes the primary responsibility of an educator as working with students in a room full of children or other learners and being prepared to deal with students across the full range of abilities and circumstances. According to the judge, an educator has to deal with students who are at the lowest level as well as students who are at the highest level. The responsibility is to do what is necessary for both. He says some of the statements he has seen from teachers distress him. Referring to his own experience as a product of the Ann Arbor public school system, he says he is troubled that some teachers appear to believe that, because Jules is who Jules is, they do not want to deal with children who might be like him. He says that this is what he sees in the statements that have been submitted. During these remarks, a woman in the courtroom apparently shakes her head. The judge immediately addresses her. He tells her that she can shake her head if she wants. But if she wants to talk in his courtroom, she does not get to talk without permission. He orders her to take herself into the hallway and asks whether she understands him. The judge's instruction is direct and reinforces his expectation that courtroom participants follow courtroom rules and do not interrupt the proceeding. After dealing with the courtroom interruption, the judge explains the next step. He says that he is elected to adjourn the hearing. There may be additional things he wants counsel to address before he makes a final decision. One possibility he specifically mentions is a full threat assessment. He says he may request such an assessment, but he has not made the final decision about whether it will be required. He also makes clear that he has not yet made a final decision concerning bond or the conditions of bond. The judge therefore postpones the bond issue until September. He explains that he had considered September 3rd, but that date does not work for counsel. He consequently selects September 10th, 2026 as the next date. This means that the current hearing ends without a final determination about the bond conditions. The judge leaves open the possibility that additional information will be requested before the court reaches its final decision. Counsel thanks the judge and then asks whether the next hearing can be scheduled during the morning session. Counsel explains that there is a need to be back in Detroit at 5 o'clock and that a hearing scheduled at a time similar to the current one might make it difficult to return by then. The request for a morning setting is accepted. The court then confirms a 9 o'clock setting for the next hearing. The judge asks whether there is anything else to address. The participants indicate that there is nothing further. The court states that bond will continue. The judge then thanks Jules and the other participants, and the hearing concludes. The transcript ends with the parties exchanging brief goodbyes. Throughout the hearing, the judge's central concern is that the court must remain separate from public pressure. He acknowledges that many people have contacted the court and that he has read their communications, but he does not treat the volume of those communications as a reason to rule one way or another. He explains that a judge does not decide a case democratically by counting opinions. Instead, the decision must come from the evidence, the allegations, and the legal process. He encourages anyone who believes relevant information should be considered to use counsel and the established procedures rather than attempting to influence the court directly. The judge also makes an important distinction between allegations and convictions. The proceeding is only at the bond consideration stage, and he says Jules has not been convicted. He has not made a finding that Jules committed the alleged conduct, and he does not know whether the evidence will eventually be sufficient for conviction. His comments are therefore focused on preventing the public assumption of guilt from becoming a substitute for the court's own evaluation of the case. Another major part of the judge's remarks concerns the treatment of people who are perceived as different. He says that the court does not treat someone differently simply because that person behaves in an unusual way. He wants the court's attention limited to the allegations and facts connected to particular charges. His repeated emphasis on facts is intended to distinguish the actual case from assumptions and opinions expressed by people outside the courtroom. The discussion of teachers and education follows the same theme. The judge says that, as an educator and professor, and as someone from a family of educators, he finds certain comments particularly disturbing. He believes an educator's responsibility is to work with all kinds of students, including students who may be difficult or different. He says teachers must be prepared to work with students across the range rather than deciding that certain children are not worth dealing with. He interprets some of the communications as suggesting that certain teachers do not want to work with children like Jules, and he says this distresses him. The woman's reaction in the courtroom produces the only direct confrontation during the judge's remarks. When she shakes her head, the judge tells her she cannot speak without permission and orders her to the hallway. He asks if she understands. The judge then moves on without allowing the exchange to derail the hearing. The final portion of the hearing is procedural. Because the judge has not reached a final bond decision and may want a full threat assessment or other information, he adjourns the matter. The original possibility of September 3rd is rejected because counsel is unavailable on that date. So September 10th, 2026 is chosen. Counsel requests a morning session because of the need to return to Detroit by 5 o'clock, and the court schedules the matter for 9 o'clock. No further issues are raised, and bond continues while the matter is postponed. The hearing therefore ends with no final finding of guilt, no final decision on bond conditions, and no determination that the allegations have been proven. The judge remains focused on the fact of the case and the proper legal process. He rejects outside communications as a substitute for evidence, warns against assuming guilt before conviction, objects to assumptions based on Jules being different, and expresses personal concern about statements made by educators. He then adjourns the matter to September 10th, 2026 at 9 o'clock in the morning, with bond continuing in the meantime, and the session concludes after participants confirm that there is nothing else to address. At the outset, the courtroom is formally called to order, and the case of the People versus Jules Cohen is announced. Counsel identifies himself and appears on behalf of Mr. Cohen. Before allowing the proceeding to move forward, the judge chooses to explain his position about the outside communications surrounding the case. His purpose is to make clear that a courtroom is not governed by public voting. He has received messages and communications from people who are not directly participating as parties, and he has made sure the parties have seen those communications. Even so, he says they do not cause him to favor either side. The judge recognizes that people may have strong feelings about the case. He even acknowledges that he may disagree strongly with some of the opinions being expressed. However, he draws a firm line between having an opinion and having a legally relevant basis for a judicial decision. In his courtroom, the decision is based on what the judge is required to consider, not on how many people write letters or how strongly they express their views. He explains that the appropriate route for people who want something considered is through counsel and the established legal system. He specifically mentions the prosecutor's office and the role of victims and victim advocates. Information from those sources can be routed through the proper channels so that counsel can examine it and decide whether it should be presented. He says the defense has the same opportunity to use the proper process. His explanation therefore applies to both sides rather than favoring one group. After explaining the process, the judge says that he has read the communications and found that some of them are not based on the facts of the case. Some of the claims, in his view, depend on circumstances that simply do not exist in the record before him. When people start with an incorrect factual premise, he says, their conclusions naturally become disconnected from the actual case. This is why he urges people not to bypass counsel when communicating with the court. The judge also emphasizes that the communications will not alter his decision. Even if additional letters arrive, they will not become a substitute for the evidence and legal arguments properly presented. His approach is to evaluate what is actually before him and to make a decision based on the facts. He then turns to the issue that he finds particularly troubling, the assumption that Jules is already guilty. The judge reminds the courtroom that the current matter concerns bond consideration. It is not a final adjudication of guilt. Jules has not been convicted, and the court has not rendered decision establishing that he committed the alleged conduct. The judge even says he cannot say whether the evidence will ultimately be enough to produce conviction. His comments are therefore directed at people who are treating an allegation as though it has already been proven. The judge asks people to reflect on this before reaching conclusions. He says that some of the communications appear to contain assumptions about Jules that are connected not to proven conduct, but to the fact that he is perceived as different. The judge rejects that approach. He says the court does not punish or treat people differently merely because they conduct themselves in different ways. The allegations and facts connected to the charges are what matter. The judge repeats the importance of the actual facts. He wants the focus to remain on the specific charges and the evidence relevant to them. He does not want the case transformed into a referendum on Jules's personality, reputation, or the opinions of people who have contacted the court. He therefore tells people to refrain from making those kinds of assumptions and repeats that any communications should go through counsel. The judge then explains that his experience allows him to recognize when public communications are unlikely to have the effect people intend. He says he has been doing this for a long time and knows what he is doing. His comments convey that outside attempt to persuade him will not replace the factual and legal process he is required to follow. The discussion becomes more personal when the judge talks about educators. He says he is dismayed by some of the assumptions made by people who present themselves as educators. He identifies himself as an educator and professor and says he comes from a family of educators. Because of that background, he has a particular understanding of what he believes education should require. An educator working with children or students can not only work with the students who are easiest to teach. He explains that teachers must deal with students at the lowest levels as well as those at the highest levels. They have responsibilities toward both. This is why the judge says he is distressed by comments from some teachers that, as he sees them, suggest they do not want to deal with children who may be like Jules. He refers to his own experience as a product of the Ann Arbor public school system and says that these statements trouble him. At that point, a woman reacts by shaking her head. The judge does not allow her reaction to become an interruption. He tells her that she may shake her head, but if she wants to speak in his courtroom, she must follow the rules. He tells her that she can take herself into the hallway and asks whether she understands. The judge then continues with the proceeding. The judge's next decision is to postpone the hearing. He says he has elected to adjourn it because there may be additional matters that he wants counsel to address. He gives a full threat assessment as an example of something he may request. He is careful not to state that such an assessment has definitely been ordered. Instead, he says he may request it and has not yet made the final decision. He likewise says that the final decision concerning bond and the conditions of bond has not yet been made. The hearing, therefore, cannot produce a final resolution on that issue. He decides to move the matter to September. He had considered September 3rd, but counsel cannot make that date. So September 10th, 2026 becomes a new hearing date. Counsel then asks for the next appearance to take place in the morning. The reason given is a travel obligation involving Detroit and a need to be back there by 5 o'clock. Counsel is concerned that a hearing at the same time as the present session might make that return difficult. The judge agrees to a morning session and ultimately sets the hearing for 9 o'clock. The court asks if anyone has anything else to raise. The response is no. There are no additional objections or requests. The judge confirms that bond will continue and then closes the proceeding. The participants thank the judge thanks Jules, and the hearing ends with brief farewells. Taken from beginning to end, the proceeding is therefore a discussion about how the court will handle a case surrounded by outside opinions. The judge does not deny that communications have been received. Instead, he says he has read them and shared them with the parties. His objection is to allowing those communications to function as though they were evidence or votes. He insists that proper channels exist for information to reach the court and that counsel should determine whether outside information belongs in the proceedings. The judge also draws a sharp distinction between what people believe and what the court has actually decided. The public may have conclusions, but Jules has not been convicted. The judge has made no final ruling on the alleged conduct and does not know whether the evidence will eventually support conviction. Because the hearing concerns bond, he considers it inappropriate for people to treat guilt as an established fact. His comments about Jules being different are similarly tied to judicial fairness. The judge says that the court is not supposed to treat people differently because they behave differently. The proper focus is the allegations and the facts related to the charges. This is why he repeatedly returns to the word facts and tells people to refrain from assumptions. The judge's remarks about education express his personal reaction to the communications he has received from teachers. He believes educators should be willing and able to work with students across the full spectrum, including those who may be challenging or unconventional. He says that some statements appear to show an unwillingness to work with children like Jules, and he finds that distressing given his own background as an educator and professor. The brief confrontation with the woman reinforces the judge's control of the courtroom. He allows no unauthorized speaking and directs her to a hallway after she reacts visibly. The hearing then returns to its procedural purpose. Finally, the judge postpones a bond decision, leaving open the possibility of a full threat assessment and other requests to counsel. September 10th, 2026 is selected because September 3rd does not work for counsel. A 9 o'clock morning time is chosen so counsel can return to Detroit by 5 o'clock. Both sides confirm there is nothing further, bond continues, and the court concludes the session. The district court session begins with the court calling the matter involving the people and Jules Cohen. After the case is called, counsel acknowledges the court and appears on behalf of Mr. Cohen. Before proceeding, the judge pauses to explain how he approaches decisions in this courtroom. He says that people do not always understand how courts work and makes clear that judicial decisions are not based on popularity, public pressure, or the number of people who support one position. He has received a number of communications from people who are not parties to the case, and he has shared those communications with the parties. Nevertheless, he states that the communications do not sway him in either direction. The judge explains that although the United States is a democracy, a judge does not decide a case by taking a vote. He may appreciate that people have opinions about the matter, including opinions with which he may strongly disagree. But those opinions are not the standard by which he decides the case. If people want information or concerns brought before the court, they should use the proper legal channels. Those on one side of an issue can communicate through prosecutor's office and through appropriate counsel. Victims, victim advocates, and others may also provide information through the established process so that counsel can review it and determine whether it should properly come before the court. The same principle applies to the defense side. The judge then discusses the letters and other communications more directly. He says that although people may have spent paper, ink, and effort sending them, those materials do not determine his decision. He says he will make his call from what he sees in the case and from the facts. He has read the communications, but he says some of the comments are not factually based. In his view, some statements rely on facts that do not exist in this case, because conclusions have been built on non-existent or inaccurate premises. He describes many of those conclusions as statements, showing a lack of understanding about the actual circumstances. He therefore advises anyone who wants to provide information to send it through counsel and let counsel decide whether it should be presented to the court. The judge stresses that communication submitted outside the appropriate process will not have a different effect on him. They will end up in the same place as the other outside material and will not change his decision-making. He says this especially matters because the court is currently dealing only with bond consideration. Despite that limited stage, he has seen statements that appear to assume Jules is already guilty.